Next, I want to introduce another author, Amy Bach, who we've heard a little bit about already this morning. She is a member of the New York Bar and the author of Ordinary Injustice, How America Holds Court. She did all of the work on this book through the generous support of a number of fellowships that she earned. She is an attorney who went to Stanford Law School. She is based in Rochester, New York, where she's founded an organization called Measures for Justice to help act on some of the book's conclusions. And this semester, she's also teaching law at the University of Buffalo. And please help me welcome Amy Bach.
Thank you so much for introducing me. I want to do these 4 things today. The first thing I want to do is tell you about this book that I spent 8 years writing. It's called Ordinary Injustice. So I'm going to explain to you what ordinary injustice is. And there are a lot of people here I know who think you know what ordinary injustice is, and you might. So I'm going to be extremely entertaining during those parts. Now, the second thing I want to do is I'm going to tell you about a new organization that I've created. It's called Measures for Justice, and it's based on the book's conclusion. And the third thing I want to do is tell you about the idea and really to stress to you how much I like Texas. I love Texas, and I would love to do a pilot here sometime. We're in discussions right now with 3 pilot jurisdictions throughout the United States on a national basis. But there's no place like Texas, and there's no place that has some of the people who care so much about justice. So that being said, here's the idea. The idea is, of Measures for Justice, is to find systemic problems in the criminal trial courts in America. The idea is to create a justice index that will gauge how well or poorly the courts are performing on an ongoing basis. And the idea is to change these 3 areas. Each indicator in our index goes towards one of these 3 things: enhancing public safety, protecting the constitutional rights of every victim and defendant, and the third is improving courts' fiscal responsibility. Now, I am an attorney, but I was a journalist before law school, and I want to explain to you how I got here to be founding this organization, and I want to tell you, really, I want to take you back to 2001 and explain to you why I wrote this book. I had written for a number of publications. When I was a journalist, I wrote for The American Lawyer, The New York Times, New York Magazine, and I decided to go to law school. And after I graduated law school, I clerked for a judge, and the circuit is the 11th Circuit, which, as you know, is Florida, Alabama, and Georgia. And I had an idea to write a little story about voting rights in Alabama, in Selma, Alabama. And I wrote this story, and I don't know what I did when I wrote this story. I've tried to recreate how I did this, but it was the only story I've ever written that got picked up everywhere. It was picked up by People magazine, the New York Times, and The Nation, who I wrote the editorial for, was extremely excited. And they said, if you can do this again, we'll give you a year. You can write about anything having to do with civil rights that you want. And you can just propose stories to us, and we'll fund you, and we'll send you around the country. And to me, this seemed pretty good, because I wouldn't have to decide what job I was going to have to really, commit myself to after law school, and it sounded very fun. So I began proposing stories to my editor, and I proposed a story on indigent defense, on the problem of the right to counsel, but really focusing on Georgia, which was considering putting a statewide public defenders system in place. So I went down to Georgia, and I picked a county where I didn't know much that was going on, but that I had heard was having some problems. And the county is called Greene County, Georgia. It's about 2 hours east of Atlanta. And you drive up to this place, and it's just beautiful. It's on this lake, And the courthouse is perfect. It's like if you had to pick a setting for a John Grisham novel, you probably all know courthouses like this, in rural Texas. It was just, they had the white columns out in front, and inside the courtroom, they had those moldings around the ceiling and these stars going around, and these dark floorboards, these creaky floorboards, and these creaky, long, dark wooden benches. Anyway, I walk up to the stairs to this courtroom, and I see there's a swarm of people, maybe 80 people, and they're all waiting around to try and get 1 minute with the public defender. And the public defender's name is Robert Surnsey, and Surnsey is wearing a loose suit. He's got this red, sort of scruffy, red hair that's, a little bit uncombed, and he's going like this: stand back, I promise to talk to all of you before you appear before the judge. And basically, here was how he managed the fact that he contracted with the county to represent all the defendants that the county could charge. And he had been doing this for 17 years or something, and his pay really hadn't gone up, and he did this in addition to having a private practice, and he would just meet with people in the hallway, and he would read them from a sheet and say, here's what the prosecutor's offering you. Then that person would go before the judge, and Robert's their lawyer, and he would stay outside when the person went before the judge. And when the person was called, another lawyer, who Robert was paying a couple $100 just for the day, would stand beside the person, and the person was expected to plead guilty. And in this way, Robert that day pled 48 people guilty. And it was extremely obvious when he was doing this that the people who he represented really had no idea what was happening to them. One would start to cry and say, wait a second, I didn't realize I was going to jail. I was pleading guilty and I was agreeing to go to jail. What happened? And the judge would have to adjourn the case because the person didn't understand. She'd never talked to her lawyer before, really had a substantive conversation. So when I thought, to me, things looked really bad. And so I went to the judge and the prosecutor and to Robert himself, and I said, how do you think things went today? And they all said the same thing, which was fine. And actually, Robert said one thing I'll never forget. He said, nobody was treated bad today. Nobody could say that they didn't have their day in court. And what astonished me and what made me want to write a book is that there were these smart people. Robert was actually smart. If you talked to him, he knew the law, and he did seem committed. He had an intention that he was doing justice, and they all did, the prosecutor and the judge as well. And yet he was routinely acting in ways that fell short of what it is that people in their positions were supposed to be doing. And they really had no idea that anything was missing. Now, this is the cornerstone of ordinary injustice, that people were acting in ways that had devastating behavior for the people that they were supposed to be representing, and that their mistakes were becoming routine, and they didn't see any role in their own mistakes. Now, there was something else that happened this day in court. So I'm sitting on one of those dark, long wooden benches, and there's this guy sitting next to me, and his name is Steve Bright. And he's head of the Southern Center for Human Rights. And he came because I asked him to come. I told him I was going to sit in this court, and he said, well, I've never been to that court. I'll come and sit with you. He was one of the people advocating for a statewide public defender system. So he's sitting next to me, and I'm trying to take notes for my story, and I can't hear anything because there's so many people, and they're all rustling in those dark wooden benches. And so Steve says to me, you can't hear. Why don't you ask the judge to speak up? And I look at him and I say, no, I can't do that. I can't ask the judge to speak up. And so he sees me struggling to try and write something, and he all of a sudden, he has this sort of this long, lanky form. He shoots up in the seat and says, Your Honor, if you wouldn't mind, please speak up. We can't hear. Thank you very much, and sits back down. And the whole courtroom, the place is packed, just whoosh, like whooshes to look at Steve and me. And Steve, and the judge says, who are you? Come before me. And so Steve sort of crouches up and says, Your Honor, we just would like to hear, if you would just mind speaking up, thank you very much, and sits back down. And she asks him again to come before him. He crawls over everybody's legs, and he gets before the judge, and he says, Your Honor, we're all here. We're missing work. We've left our children in the care of others. This is a public hearing, so if you wouldn't mind, please speak up. And the place went mad. Like, everyone's clapping and saying, amen, and that's right. This is our right to hear. We can't hear. And she's, like, pounding on the gavel. And she says, all right, I can tell there's a lot of interest in this. I have a cold. I have a terrible cold today. That's the problem. So I'm going to take a 15-minute break. So in the break, all these people line up to ask Steve if he will be their lawyer. And she came back and she installed a microphone and she went like this. She went, can everybody hear? And the people in the back row were like, no, we can't hear. And she does it again. Can everyone hear now? Yeah, And so it went on like this. And for the rest of the day, everybody, in fact, could hear. Now, here's the drive-at-home point that I want you to remember. The next day, I went back to that court. Steve goes back to Atlanta. And I went back to that court dozens of times for weeks on end over the next 5 years. There was always that huddle of the judge, the prosecutor, defense attorney at the bench, so that nobody in the court could hear. There was always that huddle at the front of the room, and there was never another microphone. Now, this is what the book is about. The book is about the huddle at the front of the room. It's about professionals, people like me, people like you, who become more attached to the people we work with than making the checks of the adversarial system work. Now, that huddle that I talked about, I see that everywhere. Anywhere that the incentives are to protect people in power and not for the consumers and users of a system. Okay, so the central thesis of the book became the huddle. It became the idea that there's basically an adversarial triangle. There's a judge, there's a prosecutor, a defense attorney, and they're all trying to check each other's work. Okay? And when it doesn't work, one of the pieces kind of falls down. This, by the way, this is not my idea. This is, I taught a course where I live at the University of Rochester. I'd like to footnote my students here. They came up with the idea that it's supposed to be like a triangle. Everyone's checking each other's work, but when it doesn't work, one part stops doing the job and the rest follow, and it becomes like an arrow, and everyone's shooting towards something, but it's not justice. Now, the interesting thing about the research for the book, so I began the book thinking, by the way, I decided to write a book after this whole thing happened. And at first I thought, I'm going to write a book about indigent defense. And the thing that became so amazing was watching how the other parts of the system collapsed. And we often diagnose problems as indigent defense when, in fact, the other parts have collapsed as well. And I think that's one of the interesting things about this is that if you can poof up the indigent defense part, the other parts, become reinvigorated as well. I was in a county called Quitman County, Mississippi, which again is it's a different kind of beautiful than Georgia, but it's the Delta. Very, very poor, and I went to the court, and unlike Georgia where there was a line out the door, here there was like nobody in court. There were about 8 people in court. And so I couldn't figure out what's going on. I start passing out my card. My phone's ringing off the hook. People are telling me one story after the next. I can't figure out, what are these about? So I go to this woman. Her name is Miss Brenda Wiggs, and she's the clerk of court. And she has a helmet of white hair and these bright blue eyes and a very simple way of talking. I said, Miss Wiggs, what is going on here? My phone's ringing off the hook. These stories are horrible that people are telling me, but I just can't see what the common denominator is. And she says, you want to know? I will tell you. And she points to a list of cases above her desk. And these are cases where a lower court judge, at what they call justice court there, I think you might have something similar here, and the local court would find probable cause, bound the case over, charge the person with a crime, and they would be in circuit court. And then the circuit court, in circuit court, the prosecutor by law in Mississippi has to present all cases to grand jury. But he rarely did present cases to grand jury. In fact, she had a list of 50 cases he was supposed to present this week, but he only presented 5. And I said, well, what happens to the other cases? And she goes, I have no idea. These people call, and I can't tell what's going on. So I said, well, can I see this list? She says, yes, use my Xerox machine. So I take her Xerox machine, I Xerox the list, and I start cobbling together all the police reports, all the files that she has in the lower court. And what I tried to find was patterns to see what kinds of cases weren't being prosecuted. And what I learned was this. When the prosecutor really cared about a case, like a big murder case that everybody, in the town was worried about, he would go full hog. He would do anything he could. But when there were cases that he could put aside and the people wouldn't form a constituency for it and wouldn't rally, he would put them aside and no one would ever know that these cases weren't prosecuted. For example, I drove up to a dirt road and I met this woman. She had been beaten up by her boyfriend underneath a bridge. Her daughter and her niece were inside a locked car watching her be beaten with a tire iron to the point where she couldn't move when she got home, and her mother scooped her up, brought her to the hospital. She was in the hospital for 3 days. There's a police report showing, a hospital report, showing the bloody contusions on her face and her back, and she never went back to live with him again. And so why wasn't this case prosecuted? I tried to figure it out, and she never moved back. She never moved in with that boyfriend again. So that wasn't the reason. It wasn't like she wouldn't comply with the prosecution. What was it? What was it? So I finally went back to Miss Wiggs, and I said, I can't figure out, why wasn't this case prosecuted? And she said, you know what? Let me see. When was the last time a domestic violence case was prosecuted? And so we looked back in these books, manually in these books that she had these records for, and it turned out this district attorney hadn't prosecuted a domestic violence case in 21 years. Now, there were other categories of cases that disappeared as well. But the point here is that we can't see these patterns of errors, these hard to see patterns of errors, from indigent defense to prosecution. All of it is hidden behind the facts of the case. Now, another chapter in the book focuses on something that you all are interested here in the indigent defense world, because it's about a judge who denies people counsel and gives extremely high bails. This judge, his name is Hank Bauer, was thrown off the bench in New York. And when I first met him in New York, it was like, I met him in his town. It's called Troy, New York. It's a bedroom committee of Albany. I mean, this guy was like the most popular person in this town, okay? You would walk around with him and people would hang out of their windows and be like, Hank, you need an umbrella? Let me give you an umbrella. Hank, you need money for your re-election campaign? I mean, he was just beloved. And what I found was that what he would do is he would, if he had a relationship with an attorney cared about his client, he would really focus on that client. But when no one was looking for, a defendant who no one really was advocating for, Hank would behave in ways that didn't comport with the Constitution. For example, there's this one guy, his name is John Casey. He's a little bit of the town drunk. He drank these enormous beers, like the huge kind, and he told me they cost 50 cents, and I know it's true because he asked me for money for one, and he would basically drink in public places, and he kept on getting rearrested. And so what Hank would do is it was this kind of Mayberry-like, he would put him in jail, and then the clerk would read his name, and then Hank would plead him guilty for him. Like, don't even bother to bring the guy back into court. Just plead him guilty for him, because we know he's going to plead guilty. He has no choice, so let's just plead him guilty. And the guy would run, and in the transcript, there's Casey coming into court and saying, well, what happened to my case? And then the clerk saying, oh, you pleaded guilty. And he's like, okay, and then he leaves. But another good example, he gave, a $25,000 bond, no attorney, to a homeless man who had been arrested for riding his bike on the sidewalk without a bell, which is a terrible crime. It happens all across America, that these little kids are riding their bikes on the sidewalk without a bell, but now we finally got this one guy, this homeless guy, which is great. And another example is there was this nurse. This nurse had 5 kids, never been arrested before. She's sitting on a stoop, beautiful spring day, which you really need in upstate New York. You want a beautiful spring day, and she was braiding her friend's hair. She's arrested because there was a no loitering sign on the stoop, and she was given a $25,000 bail, not assigned an attorney, after 8 days in jail. Her her co-workers brought her socks in jail. They visited her. After 8 days, she's finally brought before the judge. She pleads guilty, and she thinks to herself, you know what? I'm going to plead guilty, but I'm not going to pay that fine that they're giving me. She walks out of court, and she thinks, I'm never going to pay that fine. She goes and throws herself a party. And then a couple of months later, she's applying for public housing, and she finds out that she loses her public housing because she has a criminal record now. So one of the important things about ordinary injustice is the collateral consequences, the things that you don't see, the harms, the lost jobs, the lost housing because of the criminal record. Okay, now here's the interesting thing, is that what I've just told you about are these three kinds of systemic problems where the system is sagging, right? These are hypo ordinary injustices. These are times when the system, people aren't doing their jobs. But what we all know about, in the last chapter of the book, which I'll just touch on briefly, is about the hyper-adversarialism here. And that's the stories that you all know about that do make the front pages. These are the innocence cases. These are the cases where the system just, goes into full gear and everybody is just, really trying to get these two guys. And in this case, the two guys were two 17-year-old boys in the 1970s who were convicted for raping and murdering a little 11-year-old girl. And the prosecutor in the case, after 17 years, came forward and said, I think I could have made a mistake in this case. And based on his tip to the Wrongful Conviction Center at Northwestern, those two boys, who were, now men because it took a while to find the DNA evidence, were exonerated. And I said to this prosecutor, his name is Tom Breen, I said to Tom, why did you wait so long to say something? Why did you wait 17 years before you said something? And he said this thing which really goes to the point of culture, which is, he said, it's hard to rock the boat when you're in the boat. And what he's talking about is, as you all know, this culture, this courtroom culture that develops, and you feel bound by it. And, in Robert's situation, Robert Cerncy, the public defender in the first, he felt this pressure to move cases forward. It can manifest itself in a number of ways. But that is one of the ideas of ordinary injustice. This idea of that there are all these problems in communities, but we can't change what we can't see. So this is the way I often think about it. All through the book, I talk about all these things. I talk about, case workload, and there's historical biases, and a lack of transparency, and these ridiculous, antiquated practices that need to be updated, and resistance to change, and resource constraints, and culture. There are all these things, and I talk about them, and we sort of get into a circle here. What are we going to do to solve this problem? Because it's so deep, and it's so cultural. It's so based on years and years of history. And as you know, change is incredibly hard to make. What can we do to change? So for the conclusion of the book, I struggled, and I came up with 100 different conclusions. And what I wanted to say was that people need to stand up. People need to get up and say, I will not stand for this in a courtroom, and be courageous. But the problem is, everybody in my book who stands up, and in every chapter, they're what I call upstanders. Everyone is either fired or smacked down. So that didn't seem to work, because one person against a whole team usually can't survive, because it's what the social psychologists call as a strong situation. So I started thinking about it, and I started writing about it, and I started looking into ways to measure hard-to-see solutions. And the idea is that in every major public institution in America, we measure how they're basically performing, right? We measure, we all know where the good schools are, right? We know because of test scores and because of teacher-student ratios and college acceptances. But what do we measure in our courts, really? I mean, some courts have their dashboards, but generally what the public knows about are win-loss records, or clearance rates, or conviction rates, and really not much else. A quarter of the adult population has a criminal record. Can you imagine leaving something unmonitored that has affected 1/4 of the nation's adults? No one's keeping track of what kind of cases go or don't go to court. We have no idea how many cases are being pled and what kind of crimes are being prosecuted and for what reasons. Yet, we do know how much we're spending per pupil, and we do know what that investment yields in terms of test scores and teacher-student ratios and graduation rates. You know, in sports, I think about sports all the time. We keep track of every stat in the world so that we can see how to improve the qualities of our teams. The idea is that we need to start doing this for the criminal justice system. Now, this is a controversial idea, and that's one of the reasons that I think Texas could be good, because I think that it's an idea that's going to take hold, but it's not one that for a lot of reasons people are willing to get on the bandwagon for, because how is the answer going to be in a number? How could a number possibly create change? So let me explain to you how this works. The idea is to create a justice index to measure delivery of basic legal services. The patterns of civil liberties violations and malfeasance by lawyers, prosecutors, and judges can be identified. This will give courts incentives to compete. The idea is to find a county and another county and another county and another county, another county in states, and build it up. And the idea is to reach into the heart of America and basically ask these local courts, how are you doing? It's very much, the solution is very much what happened in Luzerne County. I don't know if you guys remember, but there was a lot of press on this. Dateline, did a big story. It was on the front page of the Times, where basically what happened was there were children who were coming to juvenile court in Luzerne County, Pennsylvania, and they were being denied their right to counsel. They were pleading guilty to very nothing crimes, lampooning their principal on a MySpace page kind of thing, and they were being sent to a detention facility for months. And the judges were getting kickbacks for doing this. Now, what blew the case open was that there was this little justice index, and this was the fact that kids were pleading guilty at 10 times the rest of the state. And the Juvenile Law Center saw that statistic and saw this is really messed up. Why are kids pleading guilty without attorneys at 10 times the rest of the state? And they did an investigation. They brought an action. It went to the Supreme Court in the state. Nobody cared. It was dismissed. But based on that lawsuit, an investigation was launched, and then the corruption was found out. The idea is that what opens up the change is this number. So what happened was, I wrote a lot about this and received funding to create a business plan for a seed and a business plan for an organization which we are calling Measures for Justice. And I put an echoing green logo on there because we won this competition to best new social justice, social entrepreneurships. 3,000 people applied, and we won it for having one of the best ideas. And we received more seed funding, and so we are now in the process of creating the Justice Index. So the idea is to have the first of its kind monitoring method for the lower court system, and to improve the courts in these 3 areas: financial responsibility, fairness and accuracy, and public welfare. And the idea is that we will produce scorecards to counties, and these counties will then be given a scorecard, and they will be able to see how they compare. And if they rank low, we will connect them with other counties that rank high, a peer-to-peer system, and then counties will be able to bring themselves up and improve, and they will get to know other people so that they have a network. Also, we're going to have a citizen campaign to engage citizens in how their courts are functioning. It sounds extremely hard to do something like this, and it's been a very daunting process, but it's really these 8 simple steps. And the blue ones mark the ones that we've already done. The first one is that we researched, dozens of indexes, trying to find indexes that actually create change. I live in upstate New York, and I went and did a talk in Buffalo, and this guy raises his hand, and he says, here's the problem. We live in Buffalo, and every year, Buffalo ranks as the worst city to live in America. And he said, so what are you going to do? Like, every year, we're the worst. Nothing ever changes, even though we rank low. So that's why we started thinking about creating programs to create change, to go with the index. So it's not just U.S. News and World Report for law schools. It's also using other learnings from other indexes as well that do try and create change. And then we also interviewed a ton of administrative officers of the courts. We interviewed public defenders. We interviewed prosecutors. We interviewed local defense organizations. And we asked them, what would you want in an index like this? And they said 3 things. 1, give us something linear. Give us something that goes from arrest to post-conviction. 2, we want benchmarking. We want to know what best practices are so that we can compare ourselves. And 3, they want to save money. So we started with those. That was what we did. We did the review model indexes, and we talked to people. Second, we assessed the current data, and we did a feasibility study. We developed a list of red flags, basically from ordinary injustice. And then we took those red flags, and we made them into indicators using professional standards that are out there. And then what we did was I brought together some of the people that I think are some of the best people who do indicator work in this country, and brought them to Rochester, New York, where I live, and said, all right, you guys, I've got a draft of the index. Can you fix this? And they spent 11 hours in the room, and then afterwards, many emailed versions, we came up with a draft of the index. Each of the index metrics, each one had to be comparable. So in other words, you can compare something in Texas to something in New York or Wisconsin. It had to be operational, actionable, simple, and transparent. And then, as you can see here, what we did was we created a structure where the index would go from crime to post-trial, crime, pre-trial, trial and sentencing, and post-trial. And just to give you a sense of what happened in the research for ordinary injustice became the Justice Index. Remember I told you about the woman who was beaten up under a bridge while her daughter and niece watched? Well, that became an indicator because the prosecutor hadn't prosecuted a domestic violence case in 21 years, and domestic violence cases are very hard to prosecute. They often get left by the wayside. And so we created a stat, which was the number of domestic violence incidents reported in the emergency room as compared to the number of crimes the prosecutor brings to grand jury. Remember I told you about the nurse sitting on the stoop who's arrested? And remember I told you about the homeless guy who's riding his bike and is given a $25,000 bail and pleads guilty after 8 days in jail without an attorney? Well, we create an indicator that would measure the likelihood that a defendant can pay the bond. If a bond's too high, it means the defendant won't be able to pay and will be stuck in jail. The median amount of bond per offense type is that metric. Another one is the number of defendants who waive and plea the first time before a judge. If you've got a high number of defendants who plea like, in the Robert Sorensen in the Georgia courtroom, if you've got a high number of people who do that, then you've got an indication that they may not be aware of the potential consequences of their plea. This goes to fairness and accuracy. And each one of the indicators goes towards one of our 3 goals. Now, all right, I've given you a lot of information today. I just want to bring you back to the story of Robert Sorensen because I think it really goes to the point of ordinary injustice. That lawyer, who that day looked like the worst lawyer in the world, eventually lost his job, in part because I did write a story about him, and then then the Atlanta Journal-Constitution wrote a story, and then he had to go before the Georgia Indigent Defense Council, and he got up and he said all these things, and he had to leave his job, and he couldn't find a job. So by a comedy of errors, he ended up working in Houston County, Georgia, for the best public defender in the whole state. And I said, why did you hire him? And she had a whole bunch of reasons. She said, you know, their state had opted out of the new system. It was this long explanation. I said, so how's he doing? And the public defender, who then was a woman named Terry Everett, said, he's excellent. And I said, Robert? And she said, he's fantastic. And I said, well, why? And she said, he's winning his cases. And on the board, she had put a list of how many times the public defenders visit their clients in jail every day. And he always was visiting more than once his clients in jail. He was filing motions that were required, and she was checking to make sure he was doing it. And I said, and I went up to Robert and I said, so wow, things seem to be doing a lot better. You seem to be doing well. And he said, no, I've always been doing the best for my clients. And that's the idea of ordinary injustice, that none of us can really see ourselves. None of us can see truly our performance. So we need a mirror. We need someone to say to us, look, you're doing average, you're doing above average, oh my gosh, you're falling way below normal here. We got to fix this. But right now, there's no mechanism to see how are we doing so that the checks and balances can be restored. Right now, the only real window we have are these show trials, the big DNA cases. You know, that's really where we take our clue. And as we all know, there's so much more that happens in the system. Now, my proposal's super controversial. I face an uphill battle on this. And the reason is because we're talking about changing systems, we're using statistics where they haven't been used before, and we're also really talking about jump-starting change and throwing a wrench in a system. There's no panacea. I don't think that my answer is the answer, but it's a way to turn the wheel a little bit. It's a way to move things forward. And if we stay alert, and if we have faith that good things can happen, hopefully we'll see some light at the end. And as I gotta tell you, as I'm looking around all of you, I can see that you engaged with this, and I can actually see the light in your faces. So thank you so much for listening to me, and I look forward to talking to you throughout the day.